I call Alfred Ngaro.
Thank you, Mr. Speaker. I rise and take a call on the Social Security legislation rewrite bill in its first reading. And firstly, I do want to commend the Minister, which is a move, and as has been mentioned by the Honourable Chris Finlayson, that for over 50 years this legislation has been in existence, and over that period of time I imagine there have been a number of opportunities for there to be a rewrite to address the inconsistencies and the lack of clarity that's in the legislation, and yet people have passed this by. Possibly it's been a bridge too far, in the too hard basket, maybe too difficult, too complex, and yet this Minister has taken the courage of her convictions to believe that it's an important piece of legislation that does need to be rewritten, and it's important that this be taken on board in context of not just a rewrite in other areas, whether it be the SIPS Act, but also an overhaul of the system. Many people have talked about the system, of its need and of its concern, but at the same time, talk is cheap, but action actually is what counts. That's what our communities look for. So this piece of legislation, Mr. Speaker, is a piece of action, not just talk. Though there has been a number of conversations that have been taken part, this bill is an important part. It's a technical revision or consolidation of existing legislation, and improves clarity and especially the ability for others to be able to, whether they be in the legal fraternity or others that are there as advocates, Mr. Speaker, it's important that there is clarity and the ability to be able to work through the system as well. But most of all, that the bill as a whole, in its majority, there are parts, and as has been mentioned by the previous speaker, does not change the effect of the existing law. And I think that's important to point out. Mr. Speaker, I just want to talk about a few things. I may not talk about the Beatles because even I wasn't a twinkle in the eye like the previous member at the time of 1964. But Mr. Speaker, the intent of the bill as was written at that time was clearly to provide the provision for those in need. I mean, it's one aspect of our law that I'm sure that all New Zealanders would say that they are proud of. Why? Because it provides a provision for those who are in need. For undue circumstances, they need the support of the state to provide a form of protection and provision for them at that time. But Mr. Speaker, the reason for the rewrite, and there's some particular areas, I want to give some examples for that rewrite, in particular to the Social Security Act. If we talk about income assessment, work and income case managers carry out close to 1 million transactions relating to income in a year. Nearly half of those relate to income received in the previous pay period. Changing the rules around how income is recorded and assessed could save a huge time and also to resources for beneficiaries and also staff. Another example is calculating the stand downs. Complicated income calculations are required to assess whether a beneficiary will have 1 or 2 week stand down periods before getting a benefit payment. Onerous processes are required for every application, when only 3% of beneficiaries will actually have a 2 week stand down applied to them. The last example I'd like to give is also the use of letters. More than 6 million letters were sent out in the past year to beneficiaries and superannuants at the cost of more than $3 million. The Electronic Transaction Act of 2002 already enables information that is required by statute to be provided in writing and to be delivered electronically, ensuring the Act is permissive across a full range of communication methods. These are just 3 examples of how this Act will reform and modernise what we believe is the Social Security Act of 1964. Mr. Speaker, we've heard of different examples of those in the sector. I know that there have been other commentary about the fact is that of wider consultation. There has been a number of consultation with the sector and with key stakeholders, Mr. Speaker, and I think that's quite critically important that when we go into this, that we also to hear from those commentators. I'd like to make quote of one organisation in particular that has been quoted. It's not commonly an organisation that, for us on the other side here, that we would quote from, but this is from the Auckland Action Against Poverty, where they do make a statement, which was on the 4th of November of last year in 2015. And here's taken from the statements that they'd made. Government is due to introduce a rewrite of the Social Security Act in Parliament next month. MSD should focus on supporting unemployed people into decent work rather than cutting the benefits of sole parents. This is a golden opportunity for National to reconsider the entire thrust of its, in their words,
punitive and pointless welfare strategy. But even in that form, there is obviously unanimous agreement that there is a need for the rewrite. I also too want to quote from the article written by Kate Newton, Major Welfare Changes Planned, and she quotes from the law lecturer Mamari Stevens, who said an overhaul of Social Security is long overdue. Mr. Stevens said the current legislation was messy, but that should not be used as a chance to reform social welfare by stealth. I know how difficult it is to understand, and I can see how difficult it is to navigate, so part of me thinks it's a fantastic opportunity to come up with a piece of legislation that works a lot better than the current one does, in his own words. And so, Mr. Speaker, I think that's quite important as well. We've heard from the Minister herself, who actually said that, previously in 1964 in June, there was 135 sections to that legislation. There are now 491 sections. 187 have been repealed. Only 4 remain unchanged. That's a huge amount of change in this piece of legislation, and that goes to the heart of proving why this legislation is important. Mr. Speaker, I just want to conclude my remarks just on a couple of remarks that have been made, especially in regards to, I suppose, the aspect of redirecting from those who are clients that come into the system by Mr. Penihenare, and just in regards to the fact is this a just cause and action that should be taken? Well, I'd just like to remind the member, it's actually what currently happens at the moment anyway, in certain circumstances for that. So the bill makes it clear that the exceptional circumstances benefit is to be paid at the rate of a main benefit. Rates of New Zealand superannuation are higher than the main benefit levels and are linked to average wage levels. People only have to live here for 10 years to qualify at the age of 65. If it was never intended that a person who does not qualify for New Zealand superannuation would get a benefit paid at the same rate as people who qualified for it. The bill makes that clear. So what we're talking about are minor changes. They're not changes that we would say that would constitute, and I'm sure that that would raise the interest of the Attorney General, that breaches any forms of human rights at all. So I know that the concerns that have been raised have talked about this, but Mr. Speaker, we believe that this not only complies with those of the current human rights, but also too are appropriate as well. Mr. Speaker, as the chairperson of the Social Service Select Committee, look forward to the bill coming to our Select Committee, look forward to opening up for submissions and to hearing a further expression of both concerns and issues, but also to opportunities for this bill to truly make a difference to the lives of the families in whom we serve, and especially through the department as well, and to which this act has been intended. Mr. Speaker, I commend this bill in its first reading to the House.